And my primary area of responsibility is family law, which involves things like marital contracts. I do a little corporate work as well, and I try to get involved in pro bono projects when I can as well. I want to welcome everyone to today's session. We're going to be talking obviously about marital contracts. That's pre and post-nuptial agreements. So first of all, I have to give you my disclaimer. So whatever we talk about today is just, it's not legal advice. It's sharing of subject matter information. You know, anytime you get involved with legal advice, you're thinking about pretty fact-specific situations. So today we'll be talking in general. If you have a concern, if you have a question, if you're interested in getting a pre or a post-nup in Hong Kong, you can contact me. We do have a French solicitor who can help with marital contracts in French as well. So let's get on the next slides. What are our objectives for today? I want to consider 4 aspects of what I'm going to call marital contracts for the moment. We're going to look at the representation of parties. We're going to look at the legitimacy of marital deeds, which is marital contracts, and we'll look at the structure of the deed and how a deed can be challenged. You know, these deeds, anytime you have a deed like this, and a deed is just another word for a contract. When we have contracts, we're looking to create a situation where we can reduce our risk, particularly our risk of litigation. And while it is true that marital deeds can help you with that, they're not a guarantee. I mean, no contract is, right? But there are some risks to it. And that's what we'll discuss in the described challenges to the deed section. Next, I want to talk about, or first thing is to talk about representation of the parties. One thing that we get a lot will be a couple who will come to us and say, we would like a prenuptial agreement or we would like a postnuptial agreement. I'm going to pause right here for a moment and just make sure we're all on the same page about terminology. A prenuptial agreement is an agreement where you agree on division of assets before you get married, and a postnuptial agreement is the same thing, but it's after you get married. Postnups are really interesting. They're probably a little bit more secure than a prenuptial agreement, because with the prenup, there's always kind of that worry as that one party is kind of pressuring the other side type of situation. A postnup, people have gotten married already, maybe they've gotten kids, so there's less concern about the duress risk in that situation. But when it comes to structure, when it comes to the challenges, these documents are treated in the same way, basically. So representation of the parties. Each side should have their own representation. When we get a couple who comes to us and say, we'd like a PNA, I'll just call them PNAs. We'd like a PNA. Well, the problem is, as a solicitor, I need to be an advocate for my client. And it's really hard to be an advocate for 2 clients who don't have the same interests. And certainly in a prenuptial agreement or a postnuptial agreement, the parties may not have the same interests. Very often, people are getting a prenup, let's say, because one side, let's say the wife, has a lot of assets, a lot of money, very low liability. Maybe her partner, her husband, might have a lot of liability and no assets. And so the wife, the future wife, wants to protect herself against the risk of the husband's massive debt load, as well as the fact that he doesn't have very many assets. A lot of times in the background of this is family pressure. It may be that that wife has those assets, but really it's a family business. So the family is concerned of the risk of, well, what if the husband gets sued? Can our assets ultimately be attached? Are we at risk? So that's how it plays out on the prenup side. Post-nup side, I've seen it play out with either inheritance coming in. Now, normally an inheritance is going to be separate property even in the absence of a post-nup or prenup. but just to guarantee that that money coming in will be ring fenced. That's what we call it. And I'll explain that term in a few minutes. So making sure that that property stays separate. I've also seen this happen in situations where maybe a family business is being sold, or maybe the parents have really done well with their family business. They want to bring the children in. And again, they're trying to protect that asset. And that can be a very difficult conversation to have. We'll be doing a session with a counselor in October talking about how to even have these conversations and how to approach them with your partner. But we're going to leave that kind of emotional side to the side for now. We'll talk about that in October. So as I was saying, I as the solicitor need to take sides essentially. So it's very difficult for me to look at one party and say, you need to keep this asset for yourself because it's really valuable, and then look at the other party and say, you need to really have that asset because you could benefit from it. So we recommend very strongly that each side have their own representation. It is not a mandatory requirement, but I think it creates some risk for the solicitor. It puts you in a very difficult position because you're talking to your own client, and then maybe the other side has a question. And then it becomes difficult how to answer that. I can't answer that as a lawyer. I'm not your lawyer. You may want to consider X, Y, and Z. And then your client's thinking, why are you telling them to think about those things? Aren't you on my side? So we do recommend that both sides get their own lawyers. And when you have good counsel on either side, I have found it to be a pretty smooth process because both of the lawyers understand what's happening. The objective is to divide things fairly, to execute what our clients want, and to come up with a good document to manage the assets of the marriage. Highly recommend both sides get their own representation. But an issue can be, of course, cost. People want to save money, etc. Is that a penny wise, pound foolish decision? All right. Legitimacy of marital contracts. Many years ago, marital contracts in Hong Kong and the UK, and as many of you may know, the Hong Kong, was governed, followed UK law quite significantly up until 1997. But even since then, we tend to look at what's happening in the UK as a source of law. It's not the final word, but we do look at what's happening there. And a lot of times those cases are brought in. So in the UK and in Hong Kong, marital contracts, prenups, postnups, were thought to be, quote unquote, against public policy. And they were against public policy because, first of all, they contemplated people getting divorced. And if marriage is supposed to be this institution that we land in and stay in until death do us part, why would you have a postnup or a prenup? But the reality is that people do often get divorced. People are getting married, later in life when they have accumulated some assets. So this idea that it's against public policy was taken apart by a case called Radmacher versus Granitano. And that case ultimately decided, it was a UK case involving international citizens. That case decided that, look, if people, one thing I should say, it involved a German citizen, and the contract was legitimate in Germany, but not in England. So then there was a little bit of an issue about which law is going to prevail. But I don't want to get too deep into the weeds on this stuff. What the English court decided was that if the contract is freely entered into, if both parties understand the implications of the contract, and both parties understood that this was a legitimate contract in Germany, and if prevailing factors exist making it unfair, then we'll consider not holding the parties to the agreement. So it took it from being something that was against public policy to something that was allowed, but more in the sense of a presumption of legitimacy that could be overcome. So that's why I said earlier that, you know, a prenuptial agreement is a great document to get into, especially if you've got assets you want to preserve, especially if there's a bit of an imbalance in assets and liabilities on the two sides. But it is not a useful tool if you believe that this will be the end of the discussion, all right? Now, of course, in the prenup, you're going to have language that says, in the event of a breakdown of marriage, that the parties are going to merely take this document and give it to a court and say, enforce what's here. But the court may want to take a deeper look, and we'll look at that in a minute. So the Radmacher case was an English case, and then we came into a Hong Kong case called SPH versus SA. Now, the reason we're not using full names here is because matrimonial matters, family law matters in Hong Kong are filed under seal. So when the cases come out, we only use the parties' initials to maintain their privacy. Other jurisdictions don't have that policy. That's how things are handled in Hong Kong. So the SPH case said that a full weight should be given to PNAs, pre and post-nuptial agreements, and that there is no difference between a pre and post-nuptial agreement. Additionally, the courts have said, that contract law, courts in Hong Kong have said, contract law principles should apply. And that was the case of WKK versus LMY, meaning that in looking at the document, was there an offer, was there acceptance? There's always, those are the two kind of basics of contract law, offer and acceptance. So there have been cases where people have tried to sort of suggest that, well, there was an agreement, sort of an acceptance of the existence of a prenuptial agreement. No, there's got to be very clear offer and a very clear acceptance. I think that although you can have a written contract in theory, I think it would be very difficult to prove the existence of an oral agreement on a prenuptial agreement. So I would say it should also probably has to be in writing, although I don't have cases to demonstrate that. There was a case, BWP versus TKP, and where it said informal agreements or modifications can be risky because they need to be in writing. So another aspect or another principle with prenuptial agreements is that the prenuptial agreement itself, the four corners of that agreement, are where the courts are going to look to determine what the agreement is. I'm going to talk more about that in a moment, but that's another contract principle, that whatever you've got written in that document, that's what we're going to go with as far as what the agreement is. We're not going to look outside of that document unless there's been a modification that's in writing in the same manner that the prenup or postnup was drafted in. We'll talk about that more in a moment. So what does the deed look like? What is the structure of that document? We're going to look at four principles with this. We're going to look at separate and shared property. We will look at how to maintain your separate property, and separate and shared obligations, as well as children and future children, which is always an interesting area. So let's look first at the separate and shared property. I used the term ring fencing earlier because the idea of the PNA is that you want to ring fence your property, the separate property. So let's say that we have party A is getting married and they have a commercial property, they own a commercial property in Central. They're going to probably want to ring fence that property from becoming an asset of the other party. So they're going to have in their prenuptial agreement a section on separate property. That property will be described. You know, at such and such an address in Central, and this is the assets of the this is an asset of party A. Party B is going to have to agree to that, and you know, this is part of the negotiation that takes place. Now, you know, if you're doing a prenuptial agreement and somebody has this commercial property in Central, very likely the other side is going to concede, okay, that's coming into the marriage. I understand that that property is going to be separate. But the discussion can become complicated when we consider retirement income. When you consider how you might manage your monthly income. Let's say both parties work. Party A is earning $200,000 a month. Party B is earning $75,000 a month. Well, are we throwing that money into one joint account? Are we going to throw in, let's say, 25% of our income into a joint account, leaving and having that be joint property or shared property, and then having the money that is excluded from that as separate property? Those discussions can get a little bit tricky because people have very different expectations of what marriage is about. You know, some people have been raised in a family where everything was absolutely shared. There was no distinction between separate and shared property, and that can be very confusing for them. But these are the kinds of things you're going to have to consider if you're thinking about drafting some kind of P&A. So you'll need to discuss and agree on what property is separate and what property is shared. And depending on the volume of property, that can be quite a long list. And it should be everything. And I'll tell you why you have to disclose everything, because when we get to the point where we're going to talk about defending a prenuptial agreement, we're going to be talking about full and frank disclosure. So it would be a mistake for somebody to think, well, Party B doesn't really know about that property that I own in Central, so let's not discuss it and then we won't have to worry about it. That's a mistake. You need to have full and frank disclosure, otherwise you're risking a litigation, a challenge to the P&A, resulting in litigation. And of course, that's what we're trying to avoid with this kind of a document. So we need to be very careful and very clear on what property we have, what property will be shared, and what property will be separate. So that will be one part of the deed that we draft, the contract. Normally there will be an attachment, doesn't have to be, but normally there's an attachment. Attachment A will be all of Party A's assets and liabilities, and then there will be another amendment or an appendix, Party B's assets and liabilities. That's part of that full and frank disclosure. Now, the next slide we're going to talk about is maintenance of your separate property. So you've come to an agreement on what will be shared property, what will be joint property. With respect to your separate property, it's very important for you to maintain that separate property with separate property. What do I mean by that? Well, let's say that that building that Party A owns in Central, there's a mortgage on it, or there's maintenance costs that take place, or you're running it as a business, so you've got people who are paying rent, people who are not paying rent, etc. You want to make sure that that separate property is paid for, the insurance for it, the mortgage payments for it, anything associated with running that business with it is paid for with your separate property. Because there is a risk that once you begin to commingle, right? So I'm going to pay the mortgage out of our joint bank account. Well, over time, it's going to be difficult to unthread those connections, right? And it will begin to look, even though you have something different on paper, it will begin to look like that property has kind of become joint property, okay? So you need to be careful about that. That takes us back to that bank account issue. If you come to your lawyer and say, I've got this piece of separate property, and we're going to have a joint bank account where we put in all of our income, well, how are you going to maintain your separate property? Now, some people have family money, so mom and dad will be maintaining that. Okay, that's fine. You don't want your spouse to maintain it. You will have, though, in that prenuptial agreement, a statement that says something like what we have here at subpoint 2. Failure to not convert separate property from joint property does not convert separate property to joint property. And what that means is you're going to say there, just because a payment was made from joint property to property that is separate property will not convert that to joint property. Now that statement can be overcome if it's been going on for years and years and years. And this is where I just want to pause and say, one thing that's difficult with prenups, but probably also with postnups as well, but let's focus on prenups. Let's assume it's a young couple, 25, 27 years old. They enter into a prenup because they've got some family assets that the families are worried about. The difficulty is 10 years later, 20 years later, let's say it's a great marriage, 30 years later, they have probably gotten very lazy about maintaining their separate property, right? Even if they have an agreement in the document that says 50% of each person's income will be put into a joint account, it's very likely that after some time, things are going well, let's just throw all of our money in together. Oh, the heck with it, let's just maintain that property from that asset pool. That's the difficulty. So with my clients, I always talk to them about taking that prenuptial agreement out, maybe every couple of years. Read through it. Ask yourself, am I being disciplined about following this? It is a bit of a risk. And let's just hope in that situation that they just keep staying together and that agreement never has to come into play. That's the best case scenario, obviously. Same kind of thing can happen with a postnuptial agreement. My only thinking with that is that sometimes with the postnuptial agreement, you come into a time of life, you're not in your 20s anymore, maybe you're in your later 30s, and you both, you understand the business risk of marriage, right? So you may have more discipline around maintaining your separate and joint property. But as I said before, there's really no distinction between the two deeds. So if you enter into one, be very careful about how you're maintaining and the discipline of following what you've agreed to in the prenuptial agreement. So let's look at the next slide. Separate and shared obligations. We talk about the assets. It's really nice to have those assets, but we have to think about separate and shared obligations as well. You're going to come into marriage maybe with some credit card debt. You might have purchased a nice car or a fancy apartment, these types of things. So that debt, you have to think about managing that debt as well. So not only do I have to declare that building as my asset, but I need to make clear what my obligations are as well and who will be paying for them. So it's just kind of the opposite side of the assets, identifying what your separate and shared obligations are. All right. Children. Children in Hong Kong and in most jurisdictions are never going to be something that you can agree to with absolute certainty. Children come into our lives, sometimes expected, sometimes unexpectedly. So you may have children at the time that you sign a prenup or a postnup. You may not have children. You can manage how you want children handled. If you don't have children when you sign the pre or postnup, basically you can just say we intend to jointly support these children to the best of our ability. What you can't do are things that are against public policy, which is the husband will disclaim any responsibility for any future children. That's not going to fly. And most lawyers wouldn't even let you put it in the contract if you wanted to. So the courts, as far as children go, will always go back to what the best interests of the children are. What are their best interests? So, if you have children, you may want to think about creating funds for them to support college in the future. Not everybody can afford to do that, and I appreciate that. But how are you going to be providing for the children that exist? Basically, with future children, you can express an intention that you will both jointly support the children. But no matter what you put in the contract, the aspect of your contract that's related to children is highly exposed to risk for legal challenges because the courts are not going to just accept what you've drafted. They're going to want to make sure that what is drafted is in the best interest of the children. So be careful about that. The courts can alter those provisions. And one thing that is typically going to be in a deed is, let's say the court decides that your provisions for children are not valid, then they're going to strike those provisions out. Most deeds will have a provision in there that says the determination that one portion of this deed is not supported by law does not render the entire deed illegitimate. All right, so we will be able to excise one portion of that deed, leaving all of the other clauses with effect. So that's one good thing. But just make sure, as far as children go, that you are aware that any provisions relating to them can be rather easily subject to judicial review in Hong Kong. And just as a little pause right here, I'm mostly talking about Hong Kong views. Many, many people living in Hong Kong, and many of the people who are getting prenups in Hong Kong are quote unquote foreigners, people who may move back home. I'm perfectly aware that many of them consider Hong Kong home and this is where they're going to stay. But if you do move, and it's not something I have a specific slide on, I'm just thinking to mention this now. If you do move, let's say you move from Hong Kong to France or to the US, you should talk to a local attorney about whether or not your pre or post-nup is legitimate in the jurisdiction in which you live, and see if changes need to be made. And for those of you who have prenups, this may now be the time to convert that prenup into a post-nuptial agreement. And I would say for most jurisdictions, that post-nuptial agreement is going to be a little bit stronger than the prenup. Now, let's get into some of the challenges to the deed. There are about 6 areas of challenges that we can talk about. Financial disclosure, independent legal advice, which I'll have a little bit more to say about, understanding the consequences, duress or undue influence, individual considerations, and being left without means. Let's take a look at financial disclosure. As I said earlier, your financial disclosure needs to be full and frank. This is kind of a legal term, meaning you got to say everything that you got. All right? You can't hide things and you can't not disclose things. And the disclosure is a worldwide disclosure. So, you know, if you've got some assets hidden somewhere, I don't know, in Germany or something like that, you need to disclose them. Otherwise, it hurts your credibility in a future challenge. And that's disclosing your assets as well as your liabilities. And, you know, just to touch on a little bit about what might be embarrassing, well, you know, if you've got one party who's really strong financially and another party who has not been as smart or as lucky financially, it may be very embarrassing. They may not have talked with their partner about this to date. And now they're being pushed to really be exposed. So consider that when you're interacting with your partner. Have discussions that are full and frank about these things. And you know that there are ways of managing these discrepancies through the prenuptial agreement. So you should have full and frank disclosure of your assets as well as your liabilities. Independent legal advice. As I've discussed before, both sides really need to get their own lawyers to get their own best legal advice, what's best for them. You know, if you don't, it's kind of, this is where a wedge can come in. So let's say the person with the money got the lawyer because they could afford to get a lawyer, and the person without the money didn't get a lawyer because they couldn't afford it. And even though they've signed everything, they could argue later, look, I really wanted to get legal advice. I couldn't afford it. I felt pressure. You know, we signed the prenuptial agreement 3 days before the marriage. What was I supposed to do? Not a bad argument, actually, right? And we'll get into duress in a minute. There's a case, and this is the case I'm about to discuss is not a prenuptial case, but it's a great case about the can and should of legal advice. It's called the Clark Boyce case, and it's a New Zealand case. And in that case, it was a situation where a lawyer made a decision to represent people on both sides of a matter. It was involving the remortgage of a home. And the money was going to be given from the mother to her son to support his business. And the son, in return, was going to allow the mother to continue living in her house. And he said, later, I'll just make the mortgage payment. So we've got mom who has a house, son who has a business that needs help. Mom says, I'll mortgage my house. I'll give you the money. The son says, great, I'll make the monthly payments. You keep living in the house. Well, we're not talking about this case because everything went well. They did go to a lawyer who agreed to represent both sides. Very difficult. What are you going to do? Look at the son and say, this is a great deal for you. Go ahead and sign. And then look at the mother and say, don't sign. This is a horrible deal for you. What if the son can't pay the mortgage? Right? Very bad. It's better to have people who are on, who have separate lawyers and being separately advised. But the mom and the son wanted to do the deal, and they said, we waive the right to have separate legal advice. Well, ultimately it goes, goes awry. The house is, lost. The mother's, out of the house, and the son is going bankrupt, right? And they decide to sue the lawyer as a result. They said, well, the lawyer, he's at fault. Ultimately, the courts decided that the lawyer was not at fault, but it took years and years of litigation to make that determination. So, if I'm teaching this to lawyers, I would say, don't do it. But all lawyers have had that situation where you have clients coming in who either don't want to because they've already decided this is what they want and I just want you to do the paperwork, or there are real financial stresses. So that's when lawyers can maybe figure out some creative alternatives to make sure that both sides get the legal advice that they need. But the takeaway from you all, make sure each of you have independent legal advice. You can, if finances are a major issue as well, one side should pay the legal fees of both sides, and we do see that. The risk there is, well, since lawyer B is getting paid by the client of lawyer A, is it fair? And that can be addressed in the prenuptial agreement as well. So there are a few ways to get around the financial burdens. Full understanding of the consequences of entering into the prenuptial agreement. One thing that we have seen at times is that clients will come in making a deal that we feel is not in their best interests. So then there's that tension between, well, does the lawyer think that the client needs versus what the client wants? So let me take you back to your separate property situation and a joint bank account. So we've got separate property, that darn commercial property in Central, and a joint bank account. And the parties say, we really want to just put all of our income into one bank account. And if they insist on that, I, as the lawyer, really need to make sure that they understand that they may run into a problem with maintaining that separate property with separate property. Because where are you going to get your income from to do this, right? Especially if we're defining income broadly, and any income that's generated from the business in the separate property goes into the joint account. So really that's, and I'm sure that you can see, oh, my computer just died. Hi, everyone. You know what, my computer's still working. See how you're on it. Let's just put here. Move this one back. What's going on? Hi, sorry about that. I had a little technical glitch there. We're back on track now. So full understanding of the consequences. You need to make sure that your client understands those risks. The client may just be thinking, well, I want to be fair to my partner and have a joint account where we put our money in. That's going to be the lawyer's job to really explain that to you. So just making sure that they understand. Now, when I do my, when I finish up my prenup, I will give my client a letter and explain how to maintain the prenup, like check it every couple of years, etc. But I will also have parts in there where I say, perhaps you shouldn't sign for the following reasons. Normally they sign anyway, but at least there's been an expression of that warning. And we will have talked about those things before. So now, duress or undue influence. You know, if you've got someone who's signing the prenup an hour before the wedding, there's a pretty good argument they can make later to say that the prenuptial agreement is not legitimate because I was under duress. We like, from a legal point of view, we like for there to be at least a month before the wedding. Normally, people are only coming to us the month before the wedding. So if you are thinking about a prenup, get it done early, all right? You know, it's better. Get it done, get it out of the way, and then enjoy the wedding planning, which is oh so much fun. So there is a case where, you know, people have been successful in arguing that they were under duress or undue influence. Again, that's going to be a really deep factual analysis. It's going to cost a lot of money to prove that, but there is some risk of that. So get those prenups done early. Don't pressure your partner into doing it. Make sure everything is really voluntary, and be cooperative in the process in order to make it a successful deed. In the case of MKK versus YS, there was an amendment to a prenuptial agreement, but they did not draft that amendment in the same manner as the prenup. And the courts found that that amendment was not legitimate, all right? So understand, again, contract law principles. Whatever is in the four corners of that agreement is what the agreement's going to be. So you need to make sure that if you make changes, go to a lawyer, get it checked out, have it be signed by both sides, make sure it's in writing with the same formality as the deed itself. That's the language that the courts like to use. Individual considerations, you know, in addition to differences financially, you could also have situations where, you know, one of the parties is, you know, in his 60s or 70s, the other party is in their 20s and 30s. There's a huge age difference there. There can be differences of maturity in these situations. Where you have that, I would have something in the deed about that, acknowledging that there's a large age difference. In order to, you know, accommodate that, we're making the following concessions. Same thing with maturity levels as well. Also, pay particular attention to emotional state, whether there's that undue influence or pressure. You know, it can be a very emotional thing, which is why we're going to team up with a therapist and talk about this in October. I think your bigger risk in this category is the age difference or the maturity level. Finally, being left without means, and this really applies especially as to the children. If in the end, let's say we have a prenup, there's a divorce happening, and the parties say that, well, one of the parties says, whoa, we signed a prenup, or whoa, we have a postnup, but the other party is going to be left destitute, without any means, particularly if the children are going to be left without means as a result of enforcing the prenup. The courts are going to say, nope, we're not going to look at this. We're not going to leave somebody who's going to be sleeping on the streets. So if you're in a situation where you see that happening and you see that the prenup's not going to quite cut it, or the postnup's insufficient to support the other side, you're going to have to come up with some ways in negotiating the terms of your divorce to make sure that the other person's taken care of, probably in excess of what was anticipated by the prenuptial agreement. So prenups are legitimate. They are no longer against public policy, but the courts are still going to bring in common sense as to how people should be treated, particularly how children should be treated. So that's all that I have to say on prenups for this talk. Does anybody have any thoughts or ideas or questions? I'm ending a little bit early, but I imagine that that's probably welcome. You can go grab some lunch still. All right, well, that's everything from me today. If you have any questions or thoughts or ideas, feel free to get in touch with us at JC Legal. We'd be happy to, direct you someplace or provide some legal services to you. Thank you, guys. Happy Tuesday. I think maybe I wasn't touching the keypad, but I kept, anyway, whatever, it worked out fine. Was that okay?